Good afternoon, dear students. Today we will talk about diplomatic privileges and immunities. As you already know, privileges and immunities can be divided into two main groups. The first one is privileges and immunities of the members of the mission. In other words, we can say that it is personal privileges and immunities. For example, of the diplomatic agent, of the members of his or her family, members of the administrative and technical staff, and members of the service staff. And the second group is privileges and immunities of the diplomatic mission, that is, of their premises. Today, I would like to concentrate your attention mainly on the privileges and immunities of the diplomatic mission. As we know, the ambassador and his staff need a place in order to fulfill their functions as diplomats. They need a kind of office that is well equipped so that they can communicate with the host government and with their own government. The building complex where the ambassador and his staff work is also called a diplomatic mission or an embassy. Thus, the terms diplomatic mission and embassy denote not only a group of people but also a building complex. Paragraph 1, Article 1 of the Vienna Convention on Diplomatic Relations gives a definition of the premises of the mission, stating that they are the buildings or parts of buildings and the land ancillary thereto, irrespective of ownership, used for the purposes of the mission, including the residence of the head of mission. The Convention does not determine where a diplomatic mission has to be located. Since a diplomatic mission is supposed to be the sending country's official channel of communication to the receiving country, it is practical and therefore typical for its seat to be in the receiving country's capital. If the host country's capital is relocated, embassies will follow, and indeed in a number of cases, countries have moved their capitals. For example, Brazil decided in 1956 to realize an old plan to move the capital from Rio de Janeiro to Brasilia. In 1960, the new capital was inaugurated. Pakistan made the decision to move its capital from Karachi to Islamabad in the end of the 1950s, and in the second half of the 1960s, people moved to the new capital. When we are talking about privileges and immunities of the diplomatic mission, the first thing we must refer to is the inviolability of premises of the diplomatic mission. Article 22 of the Vienna Convention on Diplomatic Relations states that the premises of the mission shall be inviolable. The agent of the receiving state may not enter them except with the consent of the head of the mission. Inviolability in modern international law is a status accorded to premises, persons, or property physically present in the territory of a sovereign state but not subject to its jurisdiction in the ordinary way. The sovereign state, under the Vienna Convention, the receiving state, is under a duty to abstain from exercising any sovereign rights, in particular law enforcement rights, in respect of inviolable premises, persons, or property. The receiving state is also under a positive duty to protect inviolable premises, persons, or property from physical invasion or interference with their functioning and from impairment of their dignity. Diplomats do a lot of their work at the embassy. That's why it must be granted that they can do this without being disturbed or harassed by influences from outside. Therefore, Article 22, Paragraph 1 of the Vienna Convention on Diplomatic Relations declares the premises of the mission inviolable. Also inviolable are the residence of the head of mission and the private residences of the diplomatic agents. Just as in the case of personal inviolability of diplomats, the inviolability of the premises has two aspects. The first one is that the embassy premises must be free from interference, and the second one is that they have to be protected by the receiving state. Also, in this case, inviolability is partly an immunity and partly a prerogative. The most important part of this immunity is the prohibition for agents of the receiving state to enter the premises of the diplomatic mission without the consent of the head of the mission. Article 31 of the Convention on Consular Relations and Article 25 of the Convention on Special Missions provide an exception to the inviolability of consular and special mission premises by stipulating that the consent of the site of the mission may be assumed in case of fire or other disaster requiring prompt protective action. Since this exception is missing in the Convention on Diplomatic Relations, the prohibition on entering the premises of diplomatic missions is absolute. It is up to the head of mission to decide whether he will try to cope with the emergency by the embassy's own means or whether he will call in help from the receiving state. In case of a fire, there is often no choice but to allow firefighters into the embassy building. When in August 2002, 5 men occupied the Iraqi embassy in Berlin, the German police stormed the building only after Baghdad had granted permission. However, there have been a very few occasions where a state, in the face of a serious threat to national security or a flagrant abuse of diplomatic immunity, has deliberately authorized forcible entry of mission premises. For example, in 1973, the Pakistan Ministry of Foreign Affairs informed the Iraqi ambassador of evidence that arms were being brought into Pakistan under diplomatic immunity and stored at the embassy of Iraq in Islamabad. When the ambassador refused permission for a search, a raid by armed police took place and huge consignments of arms, apparently destined for rebuilt tribes in Balochistan, were found stored in crates. The Pakistan government sent a strong protest to the Iraqi government, declared the ambassador persona non grata, and recalled their own ambassador. 10 weeks later, relations were restored at ambassadorial level by a joint communique in which Iraq declared its respect for the territorial integrity of Pakistan. It seems, therefore, that any legal justification for forcible entry would have to rest on self-defense. States would clearly be unwilling to exclude this possibility. It will, however, always be essential in case of emergency to try every means of securing consent from the head of mission, if he is available, and otherwise from the most senior diplomat or from the government of the sending state. Governments authorizing such action will always be conscious of the possible danger to their own embassy and diplomats in the sending state, and will normally wish to avoid argument over the facts by conducting any search or arrest in the presence of a diplomat of the sending state. If the entry is not perceived as justified by the circumstances, it is likely that the sending state will break diplomatic relations. In the last resort, however, it cannot be excluded that entry without the consent of the sending state may be justified in international law by the need to protect human life. In a number of cases, diplomatic missions have been entered without the necessary consent of the head of mission. Some of these cases were spectacular. The most serious violation of the inviolability principle was committed by the government of Iran in the hostage case. This is the case concerning United States diplomatic and consular staff in Tehran. In November 1979, several hundred Iranian militants occupied by force the United States Embassy compound in Tehran, ransacked the building and archives, and took the embassy staff hostage. The chargé d'affaires and 2 other diplomats who happened to be at the Iranian Foreign Ministry at the time of the attack were also detained. The militants demanded that the United States extradite the former Shah. The Iranian government did not come to the support of the embassy and the embassy staff. On the contrary, the Iranian government approved the actions of the militants. Of the 66 American hostages, 14 were released. The remaining 52 staff members were kept hostage for more than 1 year. They were only released in January 1981, after 2 agreements had been signed between the United States and Iran through the mediation of Algeria. In its judgment in the United States diplomatic and consular staff in Tehran case, the International Court of Justice stated on May 26, 1980, that the Iranian government's decision to continue the occupation of the U.S. Embassy by militants constituted a breach of Article 21 of the Vienna Convention on Diplomatic Relations. Part of the inviolability of a mission's premises is its immunity from search, requisition, attachment, or execution, as it is mentioned in paragraph 3 of the Article 22 of the Vienna Convention. In other words, an embassy is free from the explicitly mentioned coercive legal measures of the host country. How far a sending state is otherwise free from the jurisdiction of the receiving state depends on how extensive or restrictive the interpretation of state immunity is. Immunities are granted to ensure that an embassy can efficiently perform its functions. Therefore, the inviolability of a diplomatic mission's premises extends only so far as it grants the protection to the exercise of diplomatic functions. Paragraph 3, Article 22 of the Vienna Convention states, "The premises of the mission, their furnishings and other property thereon, and the means of transport of the mission shall be immune from search, requisition, attachment, or execution." Embassy cars enjoy the limited immunities from the coercive measures listed in Article 22. It may be a rare event that a bailiff tries to put an attachment to a duty car of an embassy, but the towing of embassy cars happens frequently, particularly in congested capitals. In order not to come too close to interference with the embassy's functions, towing of embassy cars should be restricted to cases of emergency. The inviolability of the premises of a diplomatic mission finds its counterpart in the prohibition on misusing a mission's premises. Cases in which the premises of a mission are used in a manner incompatible with the functions of the mission occur albeit infrequently. Misuse occurs when a criminal or a hostage is held, when private business is accommodated, when arms are stored within the premises of a diplomatic mission, or when shots are fired from the premises. A particular serious misuse was made in above-mentioned case by the Iraq embassy in Islamabad in 1973. When Pakistan's customs authorities detected that the crate addressed to the Iraqi embassy was filled with arms, the Pakistani government asked the Iraqi ambassador to allow Pakistani police officers to search the embassy. After this request had been rejected, Pakistani police officers stormed the embassy and found a huge supply of arms and ammunition. There was no doubt that the Iraqi embassy in Islamabad has seriously violated the prohibition on misusing its premises. Special attention must be paid on fiscal and customs privileges. Exemption from taxes and duties, that is called fiscal privileges, long existed as a rule of international comity recognized on the basis of reciprocity. For the first time, fiscal privileges were formulated as a general norm of international law during the codification of diplomatic law and enshrined in the Vienna Convention on Diplomatic Relations. Article 23 of which provides that the sending state and the head of the mission shall be exempt from all national, regional, or municipal dues and taxes in respect of the premises of the mission, whether owned or leased, other than such as represent payment for specific services rendered. Customs privileges, like fiscal privileges, have long existed to a limited extent in many countries and have been regarded also as a tribute to international comity. For the first time, customs privileges were also formulated in the Vienna Convention on Diplomatic Relations. Article 36 tells us the next. The receiving state shall, in accordance with such laws and regulations as it may adopt, permit entry of and grant exemption from all customs, duties, taxes, and related charges, other than charges for storage, cartage, and similar service. On the first, its articles for the official use of the mission, and the second, its articles for their personal use of a diplomatic agent or members of his family, forming part of his household, including articles intended for his establishment. As we can see, customs privileges haven't got absolute character in international law. Their scope is determined by the laws of each state, so it can often be determined on the basis of reciprocity. Paragraph 2 of Article 22 of the Vienna Convention on Diplomatic Relations state that the receiving state is under a special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage and to prevent any disturbance of the peace of the mission or impairment of its dignity. Diplomatic missions are often attacked precisely because they represent their countries in the receiving state. Therefore, they do need protection. Since the receiving state alone has jurisdiction within its territory, it alone can provide protection that includes the use of force if necessary. Consequently, Article 22, Paragraph 2 makes the protection of the premises of foreign missions a special duty of the receiving state. Missions are to be protected against intrusion or damage. Receiving states usually discharge the duties through their police forces. In many countries, policemen guard embassies and ambassadors' residences. How well they perform their function depends on their efficiency and the willingness of the receiving state's government to fulfill its obligation. Sometimes the police are unable to cope with intruders. In such cases, the military is brought into action. The receiving state is obliged to take all appropriate steps to protect foreign missions and residences. That means it has to do everything within its power. It must also try to prevent missions from suffering ordinary criminal infringements. If a government does not do everything within its powers, in the case of an attack or intrusion into an embassy, the diplomatic mission may suffer damage and the embassy staff harm. In such situation, efforts must focus on restoring the mission's ability to fulfill its functions. Intruders must be driven out and the building must be repaired and made more secure and better guarded. Of secondary importance is the question of reparations to be paid by the receiving state to the sending state. If the receiving state has not fulfilled its duty under Article 22, Paragraph 2 of the Vienna Convention, it is obliged to pay reparation. In the United States diplomatic staff in Tehran judgment, the ICJ decided that the breaches of international law committed by Iran obliged that country to make reparation for the injury thereby caused to the United States. There is also another example of reparation that was paid. Following the United States bombing of the Chinese embassy in Belgrade during the NATO campaign in 1999 against Serbia for the liberation of Kosovo, the United States paid the Chinese government $28 million for the damage to its premises, as well as $4 million in compensation for those killed or injured in the attack. So, as we can see, where a receiving state has failed in its duty to protect against intrusion or damage, it is clearly liable to pay reparation to the sending state. In this case, the breach of the obligation of Article 22, Paragraph 2 was obvious. In other cases, it may be unclear whether the receiving state did everything in its power to protect the sending state's mission. In order to avoid unpleasant controversies, some states such as Germany, the United Kingdom, and the United States pay reparation on an ex gratia basis when mission buildings have been damaged by attacks. An ex gratia payment implies that reparation have been made without recognizing a legally binding obligation. Article 22, Paragraph 2 of the Vienna Convention oblige the receiving state also to prevent any disturbances of the peace of the mission or impairment of its dignity. This prohibition includes the harassment of a mission by unacceptable noise levels. Democratic countries have difficulties balancing their duty to the secure peace and dignity of a mission with the fundamental rights of their constitutions, such as the freedom of opinion and of assembly. Since in case of a conflict between the obligation of international law and the rights and obligation of constitutional law, the former overrides the latter. It should not be too difficult for governments to find solutions that ensure the efficient performance of the diplomatic missions as representing states. The space around a foreign mission does not belong to its premises, but needs special treatment by the receiving states because it is the area from where the peace of the mission can be disturbed. Some countries have not been shy in prohibiting demonstrations in areas around the seats of their parliament or main government buildings. They could treat foreign missions similarly. Some wise remarks by the United States Court of Appeals can serve as guidelines. The court had to decide about the constitutionality of a statute prohibiting the display of hostile signs and demonstration within the 500-foot buffer zone around foreign embassies in Washington, D.C. In its decision of August 19, 1986, the court held that the statute was constitutional since it struck a balance between the international obligations of the United States and the First Amendment. The court viewed the statute as imposing only a very minor geographic limitation on speech and stated, "It does not eliminate any point of view from our political discourse, but sets aside the space immediately surrounding foreign embassies as an area free from hostile protest." It would contribute to the upholding of the peace and dignity of diplomatic missions if international practice followed this concept. Since receiving states cannot always ensure the complete protection of diplomatic missions and residences, sending states have begun to introduce security measures for their property abroad. In many countries, the embassies are surrounded by high, massive walls that have barbed wire on top. Perimeter defenses include concrete roadblocks. Access to the embassies has been limited to only a couple of visitors at a time, whose identity is checked. In some countries, visitors to an embassy are subjected to an additional check by metal detectors. Embassy entrances are often organized in a way that visitors have to pass through two doors. The second door can be opened only after the first one has been closed, giving the embassy's doorman a less chance to check the identity of the visitor. For important rooms, shutter-proof windows and steel doors are used. In many countries, ambassadors and their staff travel in armored vehicles. In order to prevent a rush of many visitors to the embassy's gate, many countries prefer to have their mission accommodated on the upper floors of the large building. For these embassies, visitors arrive only via elevators or stairs, thereby limiting the number of people who can arrive at the same time. Sections of embassies that have many visitors, such as visa sections, are often located in separate buildings. Visitors typically have to wait outside the embassy before gaining admission. The embassy's parking lot can often be used only by embassy staff. If new embassies are built, they are frequently set back from the surrounding roads and buildings, and the approach is made difficult by concrete barricades many feet back from roads. Since it is too costly to take the same precautionary measures for the residences of the ambassadors, a safe haven inside with shutter-proof windows and steel doors may be set up. States that can afford it have increasingly sent police officers or military officers to guard their embassies and residences abroad. For example, members from the United States Marine Corps guard the United States missions. Officers from the federal police guard German missions. Since these home-based security forces have no jurisdiction in foreign countries, they can take care only of the security inside their premises. Many countries hire local guards provided by local companies. Safety measures are costly and funds are usually limited. Priorities have to be set up for which the available funds will be spent on. Unfortunately, the requests of heads of missions are not always heard. Embassies surrounded by high walls and barbed wire and protected by guards with machine guns and armored vehicles do not offer a particularly pleasant view. When, as in the case of new United States Embassy buildings, window space is limited to 15% of the wall surface, the building often looks like a bunker. However, embassies are supposed to be a channel for communication and should therefore be open for contacts and visitors. While examining immunities and privileges of the diplomatic missions, a special attention must be paid on inviolability not only of the premises of the diplomatic mission, but also on inviolability of archives and documents of the mission. Thus, Article 24 of the Vienna Convention on Diplomatic Relations provide that the archives and documents of the mission shall be inviolable at any time and wherever they may be. Bilateral diplomacy is a continuous effort. It is a consistent operation only if records are available that reflect the history of the embassy's many activities. Until the end of the 20th century, documents made up the bulk of an embassy's records. The age of the information technology brought along a new form of keeping records, namely saving them on electronic media. E-diplomacy needs e-archives. Therefore, foreign ministers work on solutions to substitute the traditional filling of paper documents by filling e-documents as far as possible. A central registry of files in the foreign ministry is desirable because it can offer access to everybody who is permitted to use it. This situation demands rules about access to the files. The Canadian Department of Foreign Affairs and International Trade requested that the official who filled the document attached access rights to each document that he filled. Article 24 of the Vienna Convention declares the archives and documents of the mission inviolable. But at the same time, this convention does not define the terms archives and documents. On the contrary, another convention, the Vienna Convention on Consular Relations, does so by stating that archives and documents include all the papers, documents, books, films, tapes, and registers of the consular post, together with the ciphers and codes, the card indices, and any article of furniture intended for their protection or safekeeping. This definition can be applied mutatis mutandis to the archives and documents of a diplomatic mission. Though not mentioned, archives are to be included because it is the purpose of Article 24 to protect all information stored by the embassy. An embassy's documents include correspondence with the government of the host country, instructions from the home government, the embassy's reports and correspondence with nationals of the home and host countries. All of these records constitute the basis and the results of the embassy's work and enjoy therefore a confidential character, though of varying degrees. All documents located in the embassy are covered by the inviolability of the premises of the mission, stipulated by Article 22, Paragraph 1 of the Vienna Convention on Diplomatic Relations. Nevertheless, the Convention declared the inviolability of the archives and documents in a separate article, namely Article 24. Correspondence that is addressed to an embassy but has not yet arrived also enjoys inviolability according to Article 27 of the Vienna Convention. The protection that the Convention grants archives and documents is a wide one. It is valid at any time and wherever they may be. Thus, even after diplomatic relations have been severed, the archives continue to be inviolable. Since the embassy's documents are protected wherever they may be, they are also inviolable when they are outside the premises of the mission. Governments try to prevent, through strict rules, the removal of official documents, particularly those of a high degree of confidentiality from the embassy. This removal of official documents is, however, sometimes unavoidable. When a diplomat, for example, has to attend meetings or conference, he may have to bring along documents. If in such a case the documents get lost and are found by an agent of the receiving state, they have to be returned. The absolute protection of the archives and documents of a diplomatic mission reflects the fact that they are owned by the sending state. The occupation of the United States Embassy in Tehran by militants with the later approval of the Iranian government has been the worst violation of Article 24 of the Vienna Convention so far. According to the judgment of the ICJ, the embassy's archives and documents were ransacked and partly made public by the militants and government authorities. The International Court of Justice condemns this violation of Article 24 of the Vienna Convention. Development of modern technologies raised the question not only about e-documents, but also about the bugging in the diplomatic missions. That is, an installation of listening devices inside the missions. So embassies have become subjected to a more modern type of harassment. Some receiving states try to install listening devices in embassy buildings of sending states. Governments continue to worry that their embassies are bugged. For example, in May 1995, the Chinese ambassador in Canberra expressed concern that Australian authorities bugged his embassy. In January 2004, the Pakistani government raised the issue of alleged bugging of its embassy in London with the British government. In any case, the installing of listening devices in embassies is unlawful. The receiving country doing so breaks the rule of inviolability that embassies enjoy according to Article 22 of the Vienna Convention on Diplomatic Relations. The installation of listening devices infringes the duty of receiving state to protect the premises against any intrusion or damage, and actual use of the devices in order to obtain information could be said to be a constructive entry or search by the agents of the receiving state. Since, however, the breach violates the mission's freedom of communication rather than the physical integrity of its premises, bugging is discussed more thoroughly in the context of Article 27 of the Convention. When we are talking about the inviolability of diplomatic missions, we should certainly mention such concept as diplomatic asylum. Asylum as a general term denotes a refuge granted to an alien by a state on its own territory. This type of asylum is therefore called territorial asylum. The meaning of the term diplomatic asylum differs from this general definition. Diplomatic asylum denotes a refuge granted to a political offender or a person qualifying as a political persecutee in a diplomatic or consular mission. Diplomatic asylum is an issue where legal systems and state practices diverge. Diplomatic asylum is recognized as a right by various international treaties concluded by Latin American countries and is practiced by Latin American countries, though not always in a consistent way. The right of diplomatic asylum is always considered a right of states, not of individuals. Most countries, particularly the United States and European states, do not recognize a right to grant diplomatic asylum and insist that customary international law does not contain such a rule. Even these states, however, grant diplomatic asylum in extreme cases. When they do so, the protection of the asylee flows from the inviolability of the premises of a mission, stipulated by Article 22, Paragraph 1 of the Vienna Convention on Diplomatic Relations. In nearly all past cases, the inviolability of the premises of the mission was respected by the receiving state. But at the same time, there is no provision on this matter in the Vienna Convention on Diplomatic Relations, so diplomatic asylum is not guaranteed by this convention. There is indeed agreement that customary international law does not recognize a right of states to grant diplomatic asylum. Such a right could not develop because there is no general practice of states in this regard. Even when the United States and European countries have occasionally granted diplomatic asylum, they have insisted that they do not subscribe to the doctrine of diplomatic asylum. The government of the United States has followed a consistent policy in granting diplomatic asylum. This policy has been laid down in the Foreign Affairs Manual, which tells us the following. The United States does not grant asylum at its embassies, but is willing to grant temporary refuge for humanitarian reasons in extreme or exceptional circumstances when the life or safety of a person is put in immediate danger, such as pursued by a mob. Germany shares the American position. German missions can grant temporary refuge only in case of danger to life and limb of a person. Individuals who are not in danger but have taken shelter in a mission have to be turned over to the competent authorities of the receiving country upon demand. In October 1984, 6 opposition leaders who were sought by the South African police had found temporary shelter in the British consulate in Durban, but the British government decided not to grant them indefinite shelter. The consulate informed them that the British government would not intervene on their behalf with the South African government and that they could not count on an indefinite stay in the consulate. In October of the same year, the political leaders left the consulate. The South African authorities immediately arrested all of the individuals. It has been a tradition among Latin American states to grant diplomatic asylum. Latin American states historically have had unstable governments, and attempts to topple them have occurred frequently. Thus, there has been a need to grant shelter to those who were deposed or to those who had unsuccessfully tried to overthrow their government. Diplomatic asylum became so widespread that the Latin American countries concluded 5 treaties to agree on the details. The convention signed in Havana on February 20, 1928, and in Montevideo on 26 December 1933 did not establish a right to grant diplomatic asylum, but referred to the legal situation of the receiving country. The treaty signed in Montevideo on 23 January 1889 and revised by a treaty signed in Montevideo on 4 August 1939 did recognize a right of the contracting parties to grant diplomatic asylum. These treaties were, however, ratified by only a few countries. The convention signed in Caracas on March 28, 1954 stipulated explicitly that every state has the right to grant asylum. The convention was ratified by 14 Latin American countries. A closer look at the Caracas Convention reveals the problems in making the granting of diplomatic asylum a right of states. It has been a tradition in Latin American practice to grant diplomatic asylum only to individuals persecuted for political reasons, but not to persons sought for common offenses or whom regular courts have convicted. These principles are upheld by Articles 1 and 3 of the Caracas Convention. Another problem pertaining to diplomatic asylum is that the state granting asylum and the asylee are interested in keeping the period of time of the asylee's stay at the mission as short as possible. The asylee wishes to leave as quickly as possible for a country that is willing to give him safe haven. The state granting asylum wishes to end the asylum quickly, since it is an issue that probably creates tension with the territorial state. The asylee, however, can leave the protecting mission in most cases only with the consent of the territorial state. It is rare that an asylee can leave the territorial state unnoticed. One exception occurred in January 1980 when 6 American diplomats who had taken refuge in the Canadian embassy in Tehran after the United States embassy had been forcibly occupied by Iranian militants left Iran with false Canadian passports. In most cases, however, it is in the hands of the territorial state to decide whether the asylee can reach the frontier safely. If diplomatic asylum is made a right of the state granting asylum, the territorial state must grant safe conduct so that the asylee can leave the country without being put in danger. Article 11 of the Caracas Convention provides for safe conduct within the territorial state. This provision constitutes another important intrusion on the jurisdiction of the territorial state. The Latin American attitude towards diplomatic asylum has been criticized by many countries, but at the same time, Latin American practice concerning diplomatic asylum was helpful in many individual cases. For example, after the president of Ecuador, Lucia Guterres, was ousted in April 2005, he took shelter in the Brazilian embassy in Quito. The Brazilian government granted him diplomatic asylum referring to the Caracas Convention of 1954. In 2012, Bolivian Senator Roger Pinto, who had accused the Bolivian government of corruption and complicity in drug trafficking, took refuge in the Brazilian embassy in La Paz, claiming to have received death threats. Brazil granted him asylum, but Bolivia refused him safe passage and he remained in the embassy for 15 months. He was then spirited in a diplomatic car out of Bolivia to Brazil by the Brazilian charge d'affaires, who was concerned for the mental health of the fugitive. Brazil's foreign minister resigned on hearing of the unauthorized escape. Even longer and with far less justification under the rules of international law was the asylum granted by Ecuador in June 2012 to the WikiLeaks founder Julian Assange. Before taking refuge in the Ecuador embassy in London, Assange had exhausted legal appeals against extradition to Sweden, where he was wanted for questioning on charge of sexual assault. He claimed to fear onward transfer to the United States and prosecution there on charge arising from his leaking of diplomatic cables and other documents. Although these fears were dismissed by many legal commentators, Ecuador continued to afford shelter within its embassy and to request safe passage for Assange. The United Kingdom authorities threatened in August 2012 to withdraw the status of the premises on the grounds that they were not used exclusively for the purposes of the mission, using the provisions of the United Kingdom Diplomatic and Consular Premises Act 1987. But this was presented by Ecuador and its friends as a violation of the Vienna Convention on Diplomatic Relations, and the threat was not carried out. Instead, the United Kingdom continued its surveillance of the premises in order to prevent escape by Assange either in disguise or in a diplomatic vehicle. In April 2019, Assange's asylum was withdrawn following a series of disputes with the Ecuadorian authorities. The president of Ecuador deprived Assange of asylum, and the police were invited into the embassy and he was arrested. So Julian Assange was staying in the Ecuadorian embassy for almost 7 years. Now he faces possible extradition to the United States. The request for diplomatic asylum is a rare event in the life of an embassy or consulate, but it happens. Diplomatic missions must be aware that the asylum seekers may knock at their doors. The head of mission must instruct the members of the staff on how to react if someone tries to seek shelter in the mission. In any case, granting asylum or temporary refuge in an embassy or a consulate results in a confrontation with the government of the host country. If a diplomatic or consular mission shelters a citizen of the host country against his or her own government, it is a massive interference in the host country's affairs. The International Court of Justice states the following in its Colombian Peruvian asylum case 1950. A decision to grant diplomatic asylum involves a derogation from the sovereignty of the state. It withdraws the offender from the jurisdiction of the territorial state and constitutes an intervention in matters which are exclusively within the competence of that state. So this was the main information concerning the topic of our today's lecture. Thank you for your attention.